And in a big development in the case relating to Money Laundering Act, that's the Prevention of Money Laundering Act, which actually gives ED its powers, the Enforcement Directorate, there has been a review that the Supreme Court has agreed to do. So, sweeping powers have been given to investigating agency ED by the PMLA, and the Supreme Court Chief Justice N.V. Ramana says there's a need to reconsider two aspects of its previous judgment, which was less than a month ago. On the 27th of July, just to put this in perspective, the Supreme Court upheld the powers of the Prevention of Money Laundering Act, including the sweeping powers which allows the agency, the Enforcement Directorate, to arrest an accused without providing for an FIR or any written reasons for arrest. They can just give verbal grounds of arrest. It allows them to attach property even when the case is under investigation. It puts the onus of innocence on the accused. So you are guilty until proven innocent if you are being investigated under the PMLA. Now, some of these aspects will be reviewed. One is that which puts the burden of proof on the accused, and the other provision is not providing case documents. It's called the ECIR. The previous court order said the ECIR is not like an FIR, which you have to give. So the ECIR is an internal document within the ED, which shows the reasons for arrest. Now, these two aspects will be reviewed. The court also went on to say that while they are in full support of preventing black money, but these two aspects particularly need a relook. Supreme Court has issued a notice to the union government as well. This is on a petition by Karthi Chidambaram, who asked for a relook at the PMLA. This review petition will be now listened to, and an answer is awaited from the government. Now, to speak on the implications of this, I'm joined today by Sanjay Hegde, Senior Advocate in the Supreme Court. Ashish Chandra Singh, former Deputy Legal Advisor of the ED, is joining us on the show. And I'm also speaking with Bharat Chugh, Advocate, Supreme Court. Welcome to all of you, and thank you so much for speaking with us today on the show. Mr. Hegde, let me begin with your take. Do you think it's very significant that the Supreme Court has chosen to review two aspects of its own order in less than a month, and what are the implications of this?
There are significant implications. As you yourself said, the main judgment came out barely a month ago, and on a review petition, normally what happens is that the court just reads the petitions in chambers and says we find no grounds to review and dismisses them. The fact that they have chosen to have a full an open court hearing was significant, and today they've indicated their mind as to on what aspects they think that a relook should be done. You have told your viewers what the two aspects are. One is on the burden of proof. The second is in respect of not supplying the ECIR. Let me just elucidate further. Anybody who's arrested at least ought to know what are the charges. Why is it that he's being arrested? If all that is on a memo called the ECIR, normally in any civilized system of law, he should be allowed to have access to that so that he can then say, no, what you have recorded here is wrong. There is no linkage between me and my assets and that particular crime, or whatever is his defense. You can't defend blind without knowing the contents of the allegations against you. Second comes the question of reversing the burden of proof. Normally, you are presumed innocent unless proven guilty beyond all reasonable doubt. The onus is always on the prosecution. Here, if you are presumed to be guilty and then asked to prove your innocence, it's sometimes like answering that classic question, have you stopped beating your wife? Because then whatever you say, how do you prove a negative? How do you prove that you did not do it? More so when you do not even know what it is that is put against you. So long ago, the Supreme Court in Maneka Gandhi's case said that if you want to deprive anybody of life or liberty, then the procedure has to be just, fair, and reasonable. All these procedures in the Act appear to me, at least, to not be fair and reasonable. the accused does not stand a fair chance of proving his innocence. So I'm glad that the Supreme Court decided that we should have a relook.
Ashish Chandra Singh, from the point of the Enforcement Directorate, how much of a difference does it make to their capabilities of, discharging their duty if these two tools are removed? Of course, this will now go in for review. What happens eventually, we don't know. I'm trying to understand how much do they need these two powers. One is not to tell those that they're arresting exactly why or what the charges are against them. And the second, putting the burden of proving yourself innocent on the accused.
Yeah. Madam, first of all, I have heard what Mr. Hegde has said right now. My first argument on that point, first submission on that point is that so far as ECIR concerned, it is enforcement case information report. It is neither mandated under PMLA nor under CRPC. It is simply a domestic arrangement for the purposes of identification of a particular case. And mostly because of this thing, it is provided at the appropriate stage, like for example, if properties are attached along with the OC when they file before adjudicating authority, they invariably provide a copy of that ECIR to the all affected persons. In that ECIR, what does they mention? They mention only the gist of the FIR, because as you know, the PMLA is not an original offence. Unless and until there is underlying scheduled offence, there can't be offence of money laundering. So there must be necessarily an FIR must be in existence. Number two, the second thing is the burden of proof. My friend has just now stated that this is the cardinal principle. I do agree with that, but here I just want to draw the attention. The under section 24, there are of PMLA, it has two parts. First part relates to when a person is charged for committing an offence under section 3, that is the offence of money laundering. The proceeds of it shall be presumed by authority or by the court that proceeds of crime are involved in the offence of money laundering. And the second part only says that then court may presume if he has not been charged. So, in the first part, the statutory presumption that has been provided under first part of the act, that is statutory presumption. And here it is to be noted that it is not related to accused. It relates to the property which has been attached, which has come before the court as case property. So my humble submission is that since it is, and it has been, because of this thing, this act has been amended so many times. Originally, when the act was there, at the time when it was enacted in 2005, when it was enforced, the provision was different. And later on in 2012,
Sir, but what is the point,
which
sir,
was
you are
enforced
making?
with effect
Mr.
from
Singh,
15 February
you are telling us what the
2013.
law says right now.
Yeah.
But that's not what we're discussing, right? We're saying that does this law need to be reviewed?
Yeah,
The Supreme Court is saying it needs to be reviewed. The question today is this law as it stands fair? You are telling us in great detail what the law says today. My question is, without these special powers, can the ED not do its job?
Madam, Madam, so far as statutory presumption is concerned, that is before the court of law. How ED is concerned about that? When matter will reach to court at the time of trial, if the statutory presumption is taken away, then they will have to prove, because I have an experience of conducting so many cases which are related to economic crime. In the Economic Offences Act, the legislature always makes provision to give certain leverage to prosecution by way of drafting, by way of enacting statutory presumption. That presumption is not like conclusive proof. That can be rebutted, and that
No, so
the
you're saying there is a
rebuttal
checks
must
and balance
not
at
be
a
of
later
that
stage. It's
extent
still not
the
answering my question, sir, whether the
which
ED cannot improve its
balance is
conviction rate
already
before
made.
it. Okay, 1 minute. I'll come back to you,
Yeah.
sir. Let me get Bharat Chugh into this conversation. At the end of the day, economic offences are more difficult to prove. That's the presumption, right? Which is why this enforcement agency and the PMLA has been given these quote-unquote special powers, which are right now under review. The question then is, despite this, why does the ED have such a poor conviction record? And can they continue to do their job honestly and transparently if some of these special powers are taken away? Bharat Chugh.
Absolutely. No, CBI and other investigative agencies have been investigating matters, and important matters, which are complex investigations, without the aid of these presumptions or without the aid of these special provisions that are there in the PMLA. Are those investigations not effective? Are those investigations not up to the mark? The point here is that these special provisions that are given in favor of the ED are arbitrary, unreasonable, and unconstitutional. It turns the presumption of innocence on its head. As Mr. Hegde rightly said, it is very difficult, if not impossible, to prove the negative. If it is the ED's case that in a given matter, somebody has in his or her possession property which is the proceeds of crime or is tainted wealth, it should fall on the ED to prove that it is tainted property or proceeds of crime. How can a person prove that it is not so tainted? They are labeling the allegation and it falls on them to prove it. And ED has all the state apparatus at its disposal. Every agency, bankers and other agencies are under a law, under a duty to cooperate with ED and give it all the necessary information and evidence that it needs. So ED doesn't have its hands tied behind its back and they are not in a position to investigate matters. As opposed to this, an individual who's defending himself in an allegation for a PMLA offense does not have the state machinery to prove innocence. So that is the reason that in all penal laws, the onus of proof or the burden of proof is on the investigative machinery, because they have the power and they have the wherewithal to collect evidence. And that's the only way any civilized criminal justice system can function. And that burden of proof cannot be turned on its head, because anything else amounts to making the accused fight with his hands tied behind its back. And this is further compounded by not giving the accused a copy of what really is the allegation against him or her. Now, that is unprecedented. Every act in every jurisprudence allows the accused an opportunity to go through the allegations against him, what is the evidence against him, and then put up a defense.
That's true. But Bharat, if you go through what the Supreme Court said in its 27 July order, it said that this guilty until presumed guilty until proven innocent is not, of course, the regular way, but an act of parliament can allow it to happen. And that is exactly where the question mark is, right? That the PMLA was passed by parliament, though as a money bill. That's also another case. So does the executive have the power to do this if it feels it needs to?
See, the executive indeed has the power in certain cases to shift the burden of proof. For instance, you'd recall back in the 1980s when dowry deaths, was a big menace, and the parliament decided to tweak the law or amend the law. Now, in dowry death cases, the presumption is sometimes on the husband to prove that the death took place on account of natural causes and it is not a case of dowry death. But even that presumption under the Indian Penal Code in a dowry death case kicks in only when the prosecution proves foundational facts, when they prove prima facie to the satisfaction of the court that yes, there was some cruelty, it was in connection with dowry, and they have to prove at least 5 different facts before the presumption even kicks in. But in the case of PMLA, they do not need to prove those foundational facts and the presumption kicks automatically on day one. So that is the difficulty. And indeed, the parliament has the power, but that exercise of power is always subject to a judicial review, judicial scrutiny. In this case, this amendment or this provision is not just, fair and reasonable, and there is no justification for giving such a power to such an agency.
All right. Sanjay Hegde, just quickly on the point of how much resistance is going to come, because the central government will also have to respond Their position was made clear in the earlier case as well, and they have stuck to that broad line that the ED needs all of these special provisions to be able to execute and actually stymie financial crime. Do you expect those arguments to now be reiterated?
All arguments will be reiterated. The question is, how far will the court review it? Because judicial review is only on two grounds: either lack of legislative competence or the violation of the fundamental rights. There's no question of lack of legislative competence. Parliament is competent to create a law. But is that law constitutional? I do think that the Supreme Court judgment of July 27 looked at the Constitution rather narrowly. That, these are the rights claimed. This is what the ED says. And of course, ED can do it. That seems to be the nature of the analysis, with due respect to the judges concerned. The point is that, especially post Menka Gandhi, and Menka Gandhi is a 1978 judgment, we have ceased to compartmentalize fundamental rights. Examination of any executive action or legislative action against the backdrop of fundamental rights is much more holistic. If you want to take away anybody's liberty, that procedure must be proportionate. It must be just, fair, and reasonable. Yeah. None of those parameters seem to be provided here. And as Bharat rightly pointed out, other investigative agencies are able to do their job without this kind of mollycoddling.
I want to take that point.
As a matter of fact, I do think that mollycoddling makes the agency even more lazy. This is what is the ED after all? It is just a wing of the finance ministry. Now, in the garb of protecting the country against black money or other such offenses, that they can't have an overriding effect and an overarching reach straight into people's houses and liberties.
Mr. Singh, I want you to respond to this.
The book.
Yes. Let me get Mr.
The Constitution of India.
Let me get Mr. Singh's response to this. Other agencies don't have it. They do just fine. And such powers can make an agency lazy because they don't have to look hard enough for the proof, which eventually you will require. Like you said in your own words, that eventually at the stage of trial, you will have to come up with hard proof for convictions. Yes, Mr. Singh, that question's for you.
First of all, I would like to respond
yes.
to Mr. Hegde. So far as the PMLA Act is concerned, first I would like to tell you that till 2013, all amendments have taken place in the Parliament. Only last 2-3 amendments had taken place through money bill. This act was enacted in 2002, but it became, it got the President assent in 2003, and it was enforced with effect from 1st July 2005. So it is wrong to say that all the amendments have taken place through money bill. That is wrong. Number two, that as Mr. Hegde has stated, that with regard to that, I would like to say that so far as offence of money laundering is concerned, there are 3 ways to commit the offence of money laundering. By first stage is placement, then layering, then integration. And I have seen that unless and until you track the money 6 layers, then only you will come to know that what is the origin of the offence, what is the origin of that money which has been derived after committing some scheduled offence. And in most of the cases, what happens that these money launderers, they convert the proceeds of crime through various nefarious activity. And in most of the cases, as it has been claimed, that why the conviction is rate so poor or the cases are not decided at the earliest pace. That should be the concern, because justice delayed is justice denied.
Yeah, absolutely.
But simultaneously, in most of the cases, the money has travelled beyond the boundaries of the country, and for that you need to have recourse of letter of request. And you know that with the evidence is lying outside India, it takes very circuitous route. It takes a lot of, it
Sure.
consumes a lot of time. Under PMLA, it is the special court which has been given power to send the letter of request. So all these things, if we look at it, then we will find that it takes, consumes a lot of time in deciding the cases.
That's fine, sir,
And
but the question
secondly,
is
if
that
they have
no, no,
arrested a person, then they have to file the 60.
No, it takes a lot of time, no doubt. Investigative agencies have their tasks cut out for them, no doubt. The question is
Yeah.
about checks and balances, to give citizens also
Yeah.
the right to protect themselves
Yeah.
against possible misuse.
Yeah.
And that is why this is a very, very significant review that will be conducted. I have to wrap it here, but thank you so much, Mr. Singh. Sanjay
One thing
Hegde.
I would like to draw your kind attention.
I'm absolutely out of time, but I'll give you 10
Okay.
seconds. Yes, please, sir, since you've requested.
So, under the Act, there is a provision if any ED officer has conducted illegal search or he has conducted search which was found to be vexatious, then there is a provision of criminal case, launching of criminal prosecution and
How many have
punishment
been
up to
investigated under this,
3
sir?
months against such
How many
hearing
people have
officer.
been
But
investigated under this, Mr. Singh? How many officers have
nobody
been
has made complaint.
Ah, okay.
Nobody has complained because it has to be complained by the individual.
I'm sure, but I'm sure the people who have been
Vexatious search,
investigated are not very happy about
has
it.
to
So
be-
all right, we'll have to wrap it here because I'm completely out of time. But I think this is definitely a discussion we can revisit when there is more clarity on what the Supreme Court is saying. Mr. Singh, Mr. Hegde, and Mr. Chugh, thank you for joining us.